This is House Education, Wednesday, April 22nd. The committee is going to review S-227, an act relating to creating immigration protocols in Vermont schools. Since we last visited it, we made some changes, mostly clarifying and whatnot. And going to have Legislative Council walk us through, remind us what we have, and walk us through some of the changes that we are looking at. Rick, the floor is yours.
Good morning, Rick Sagel with the Office of Legislative Counsel. So this is your immigration protocol bill, S-227, and changes are in yellow. I'll kind of go over those changes and anywhere that there's been something that's been, of course, adjusted, we'll talk about it. Mostly technical, but based on what you all kind of talked about last time, along with testimony from the AG's office and the VSA, some kind of changes to the bill that hopefully we can discuss. So no changes on page 1 of the bill. The purpose statement stays the same. We are still in chapter 33 of Title 16. On to page 2, the definition section. No change to law enforcement officer. Non-public area of the school. I think we had some discussion about how to improve this definition. So the word authorization is highlighted. That was there in the last draft, but it's because that phrase was removed. That's why it's highlighted. Previously, it said normally requires authorization by the school to enter, etc. This draft says just authorization. I think there were some questions about could a gym teacher, authorize a non-public area of a school, and it wasn't clear, who had that authorization. So at this point, the bill would just cite back to section 1484, which is a policy that every school has to have. Their emergency access policy, section 1484, and includes any area a school administrator determines to be non-public. You'll notice that phrase a lot in this bill, school administrator. It's a new phrase in this bill. I had the help of Beth St. James kind of establishing that term. And we have it defined here in a second. So it would have to be a school administrator, which would be a superintendent or a headmaster of an independent school that makes that decision. Hopefully it's more clear about what a non-public area is of a school. Okay, number 3, definition has changed by removing a sentence. And this previously included employees, independent contractors, school resource officers, etc. As we read through the bill, the term school was used in a few different ways. It sometimes referred to the school as the institution. A school should not do this, do that. It would sometimes refer to the people at the school, like a teacher, a superintendent, a principal, etc. At this point, the definition removes the people. It just is the building, the facility, school. So it means a public school or an independent school approved under section 166. School administrator is a new definition. As I mentioned, it includes a superintendent and a headmaster of an independent school.
Can I ask?
Yeah, jump in, folks.
Why is a superintendent there and not a principal? You talked to Beth St. James, so I'm assuming that.
It's a policy choice. It was always drafted as superintendent in previous versions of the bill, and if you want it to be something,
I was going to say it's not that I'm opposed to superintendent being there, but it is typically the principal who would oversee the operation of the school itself, and I think it would need to be added. I agree.
So if we go up to line 6, non-public area of a school, what did that say previously?
So what it said previously was non-public area of a school means an area of a school that normally requires authorization by the school to enter consistent with, etc. And includes any area a school determines to be non-public. And again, remember, school included everybody who worked at the school.
Right.
There are parts in the bill where we talk about designee of the superintendents, especially the law enforcement section. You could always do that as well.
Yep.
It allows superintendent to designate somebody to operate in this area.
Yes, I think barring the objection from the committee, I would say designee would probably be the better way to go since, I'm not sure principal is a term used at independent schools.
Well, they're covered under the next.
Yeah.
Right, there's already that. master
That's
plan.
covered. And actually,
Well, no, but what we're saying is that superintendent is like too limiting and we want to allow principals
yes,
within the buildings to be able to do it.
Let me clarify my question. I really want to allow the person who actually has authority over a building to be able
Right.
to make these decisions. And while the superintendent might, the superintendent is often covering many buildings and they would designate, which I'm fine with, a principal to do it. So
Well, I just think we should, that some of our independent schools also have multiple buildings. And you would want
How
somebody,
so?
what's that?
How so?
Like St. Johnsbury Academy's got multiple buildings.
it's their one.
One campus, it's one school. I mean, that's one of the large differences here between.
To me, a headmaster is very similar to a principal,
Principal.
Okay,
whereas a superintendent is different.
off and out the building.
so,
I think there may be times where, let's go maybe section by section.
Yeah.
Okay.
For example,
we can come back to
For
this.
example, I don't know if it's the immigration resources, I don't know if you want the principals, maybe it makes sense for them to distribute those resources at each school instead of the superintendent, but I would imagine the superintendent would distribute that to the principals who would then distribute that, but again, I think maybe let's go section by section to see what makes the most sense. So if I can continue on subsection B, the immigration resources. So again, previously, the flaw in the bill was that the language said a superintendent shall. And at some point realizing that this does not include independent schools. So the intent was the bill to cover independent schools as well as public schools in the state. So a school administrator, which would be a superintendent right now or a headmaster, shall distribute these resources, no changes there, that are provided to the school administrator. Again, previously was superintendent by the AG, no other changes there. Subdivision 2, again, replacing superintendent with school administrator. Go ahead.
You said, I'm now going back to school administrator terminology, that was something you worked on with Beth. I'm just wondering, because we're going to run into licensure, like there's licensed school administrators, which is what public school superintendents and principals are, not necessarily independent schools. So I'm now worried that we're conflating licensed positions and how we refer to them. And I'm not sure that would be appropriate or set some strange precedent for what we mean by an administrator.
Well, this definition only applies to this statute. So in this case, school administrator only means superintendent or headmaster.
You could use a different term, supervisor. I mean, this is a term that we thought about, and it's not a chapter or a title-wide definition. A lot of these are title-wide, like school. And superintendent is a title-wide definition. School administrator is not. It's a newer definition. I forget which chapter it's in. But again, this is something we could change. If you don't like that phrase, we could have it be something else.
All right, why don't we keep plugging through here?
Yeah.
Okay. So on to page 3, no other changes on page, no other changes on page 2. On page 3, finishing subdivision 2, again, replacing superintendent with school administrator twice in that subdivision. Subdivision 3 has been reworked based on a recommendation from, I believe, the Superintendent's Association. This is the providing support to a student with immigration-related concerns. A, connecting the student and the student's family with an immigration advocacy institution. That language is similar to what was in the previous draft. B, this is newer, providing the student with access to mental health professionals. And I kind of want to ask that about that phrasing and what the intent would be there. Because mental health professionals could be outside of the school, could be in-house counselors. I don't quite know what you all would want.
Where did that come from?
Yeah, that's the, where'd that come from?
I believe this is the Superintendent's Association.
What was there previously?
Previously, the subdivision said three, I'm just going to read it.
Yeah.
Foster to the greatest extent possible a relationship with a legal or immigration advocacy institution that will provide assistance to a student with regard to immigration-related concerns, including a situation where a guardian of the student has been detained by immigration authorities while the student is in school.
Maybe they're assuming the kid might need a social worker at this point. That's a professional. I think that's what I'm reading, right? Mental health professional.
Well, a social worker is different than a mental health professional. I think this has more to do with the trauma that is going to be associated with that.
So does that mean if the school doesn't have a mental health professional that we're financially responsible for providing one for them?
Well, it says to the greatest, provide support to the greatest extent possible, including,
Providing the student with access to mental health professionals.
to the extent possible. All right, let's keep going and we'll circle back.
Okay, subsection C, just the previous title of the section was student records. Changing that, it's not just student records, that's student information privacy. School districts and independent schools are prohibited from. Previously, the language read schools are prohibited from engaging in and from using policies or procedures to engage in, etc. So this was from Julia Thompson. I talked about this offline a little bit. Trying to clean up that language, sometimes just over complicating the way that's worded. And also Beth helped with this. If you discuss engaging, practicing, I think you just prohibit. It's kind of because you're kind of covering everything with those words. I'll word it again. Schools are prohibited from engaging in and from using policies or procedures to engage in practices that have the purpose or effect of excluding a student from school. And the committee also had a question about, well, what about behavioral issues, right? That came up. Like, yeah, that's a good point. This could hamstring a school from actually, having a behavioral consequence for a student. So, curious what you all think. It's simpler that you just can't do these three things, and the three things have not changed. It's just the introductory text has changed.
It sounds a lot clearer.
I like it better.
I just think that why should we talk about policies, procedures? Just if you want to stop these things from being done, might as well just say, just don't do these things either, no matter how you do it in practice and policy. And okay. And then again, 1, 2, 3, the collection of this information, the disclosing of the information, and voluntarily sharing that information has not changed. On page 4, again, changing superintendent to school administrator in subdivision 1, line 7. And there's a few more times where we see that change. So skipping down to line 17, the warrant section, I'll start from the top of that subdivision. The school administrator or designee, this is where you have the possibility of a principal or some other staff member, or resource officer, shall not allow a law enforcement officer appearing on an immigration-related matter into a non-public area of the school unless the officer provides official identification and a judicial warrant. That language has not changed. That authorizes entrance into a specific area of the school and names a specific individual located within the school who is subject to a search or arrest. So this language, again, talking to Julia Thompson offline about how to get this where he would want it to be. That doesn't mean it's where you want it to be, but this is very protective. I just want to make that clear. You require a warrant that names a person that is at the school. So staff member, probably not a student, but someone that's there who is subject to a search or arrest.
just to be clear, we're talking a judicial warrant,
Yes,
and that judicial versus administrative warrant.
correct. And it also has to be, sorry, a specific area of the school too. This is very, very specific, which warrants can be, but they can also be just for a person. So-and-so, there's a judicial warrant. And again, this is immigration only. This is not all other criminal warrants. This would be a very rare type of warrant.
How challengeable would this be if we keep it as is when we talk about located within this, who is subject, we say? When we talk about specific area,
Right.
is that, you say it's very protective, is it so protective that all of a sudden somebody, law enforcement's gonna sue and say, you can't require this to be that specific?
The classic saying is Fourth Amendment is a floor, and you can always, you can't require less privacy under the Fourth Amendment. You can always require more. Requiring police to have a warrant that's very specific, you can do that. They may complain about it, but there's not really a constitutional problem with that. But I'm just letting you all know that's, usually it's a person is at their house and they have a warrant for their address. Sometimes their employer, but usually it's at their house. And they'll be arrested based on your address. And there might be a search attached to that warrant that they can search your kitchen or your bedroom, right? It's usually pretty specific. This having, a gymnasium, a cafeteria, I don't know the likelihood of a warrant being that specific.
And this is just immigration related.
Right.
Anyway, yeah, right, Case?
How many warrants, to your knowledge, have been issued for immigration related concerns within schools in Vermont?
That I've done. Yeah, I'm not the best person to answer that question.
Have you seen a lot of immigration related issues in the state of Vermont where schools are just having difficulty, or I guess with law enforcement, whether that's local police or ICE, which is a part of the Department of Homeland Security, coming in with warrants? Have we seen anything within schools that's concerning?
Also not the witness for that question. I'm sorry, the other witness.
I think it's fair to say that part of this is to have people who may be living in fear feel more comfortable about their children going to school as opposed to keeping them out of school.
Okay, so, and this is just from my understanding. So it sounds like all of this stuff is already in place. We're just saying it so that people understand that you're already protected. Law enforcement can't conduct a search without a warrant. I guess when I look at it, I question whether or not it should be more policy within the district as opposed to what we're doing, because it feels like we're already covered under federal law with some of these things.
I don't know to the extent that federal law covers protection of ICE, for example, coming in with a judicial warrant and where they can and can't go and whether. So I think this is just
I can speak to that.
Yeah, that'd be great.
That one I can. So the federal government actually allows these administrative warrants through the Immigration Nationality Act. Those are the warrants that police, ICE, DHS can use to enter usually a public building, not your house. Can enter a public building and arrest you civilly, detain you due to removal, whatever the case may be. So that's, you're not protected under federal law from this. So if the state wanted to protect schools from immigration enforcement, like that's what this bill's doing. My only just being, giving you the honest truth about the language is that it's very, very specific. And I just don't know how many warrants would ever meet that standard. And maybe that's the point. If that's the point, then point achieved. Yeah.
it is.
I guess my only other concern is just the financial lift. I understand it doesn't look like there's anything going on here, but my concern is just one more thing that's going to financially impact our district. We're already short-staffed. It's a little training, but then we've got training with this. We're going to have training with epinephrine. We're going to have training with all these other things. So my question is, Like, we're already stretched for personnel.
Yeah, I mean, this comes with the support of the public school establishment. I mean, I'd say this is probably a small lift that they're probably already doing anyway. But concern noted and always worth pointing out, is this some sort of unfunded mandate?
Not sure I understand exactly where the funding is coming from. I mean, or not where it's coming from, but where it would be necessary is what I mean in this. Principal or the superintendent is going to train. I mean, I think that can be done relatively easily.
Yeah, it's, distributing materials. All that
So
sort of
we
stuff.
copied something on our Xerox. Sorry, that's outdated.
Let's let Rick get through the rest of the bill.
Okay.
Okay, subdivision 3, so absent that warrant required, no school, or adding the phrase individual working at the school. Previously just said no school, so adding, because now we have removed from the definition of school, the people that work in the school. So ensuring that a person that is at the school working shall reveal any information about a student or school staff member in response to an immigration related request from a law enforcement officer, and then adding unless otherwise required by law. That's also just ensuring that you're not interfering with federal law that would require information sharing. That's already in the bill, but again, just kind of making sure that the bill covers that.
Sorry, can you restate the part about the federal law? You just said.
Just my
Yeah.
on the page, yeah. So you'll see in the bill references to federal law, especially 1373 and 1644 on page 6. Those are the Immigration Nationality Act I referenced earlier that requires certain information sharing, and that states cannot prevent employees from sharing that information. So you just want to ensure that you're not blocking that appropriate request from the federal government if they make the request. No change to subdivision 4. Subdivision 5, adding in the Vermont Independent Schools Association to the model administrative procedures. This is just the law enforcement subsection in the bill that requires the judicial warrant section. So because the independent schools are now clearly included in this procedure, adding them I thought was a good idea. Okay. Yeah, subsection E on the immigration agreements. Previously, that language said except as required by federal state law, no school, and then it just said shall enter. Because a lot of times it's not the school, it's the school district, or in some cases, the supervisory union that actually does these agreements. You want to include all of those entities. Okay, no other change to that subdivision. Number 2, any agreement that purports to be required by, so there's an exception, right, to one that says if it's required by federal law. So any agreement that purports to be required by federal or state law shall be subject to review by the school administrator after they have consulted with the AG. Previously, that language just had the superintendent. So again, because we changed superintendent to school administrator. Subdivision B is new because I think the committee had questions about you don't want to step on the governor's shoes. You don't want to have the superintendent doing something that they should not be doing. So at this point, once the school administrator has reviewed this agreement with the AG's office, they will provide a recommendation on the proposed agreement to the school's appropriate governing body, which could be the independent school itself, could be the supervisor union. It just depends on how that school is structured. Does that language make sense?
So it's basically saying, after the superintendent meets with the AG, gets their feedback, then takes it to their school board
Right.
and says, here's the recommendation.
Subsection F, applicability, just adding supervisor union in case It's the policies at the supervisor union level, not at the school or school district level. So adding that entity into the language. Subsection G, the policy, the model policy. I don't think there's any changes to that section. Nope. And then at the very end, we are in the Immigration Resource Guide, section 3, on page 8. The previous language used the term superintendent because we're again switching that out to school administrator. And then the schools is highlighted because it was school districts. So changing that to schools to include independent schools as well. And then the last change again from superintendent to school administrators. And those are the changes.
Right, so everybody, we were a little bit stuck, and I'm actually glad we walked all the way through it for on page 2, line 12. Actually, I'd start on line 6. In terms of who is determining the non-public, I hear some concern that limiting it to a superintendent or a headmaster may be too limiting. Yes.
So I'm not concerned about a headmaster because I'm still linking that with the role of principal. But as we walked through this, it does mention after school administrator designee or designee in some areas. I was looking at this very specifically to non-public area of the school. I have no problem. I mean, I would need to make sure that it fit in with the rest of, because this is a definition. The rest of the bill, I often, it's not even just the principal. I often think, I'm thinking more broadly now about the other impacts of changing that definition in this bill, that there are times when the superintendent is not around and they're off at a conference or something and something might happen. And I want to make sure that in every instance in this bill, there is someone in a public school, or I'm not sure, I have to think about whether we need it also like headmaster, but that there's often an assistant superintendent or somebody who they may have to designate when they're not around.
What the goal here, what I'm hearing is like everywhere beyond line 6 in the whole bill where we say school administrator, I think superintendent is totally appropriate and limiting it to superintendent and headmaster. But in the designation of non-public areas of the school, can we create more latitude so that an assistant principal in a high school could designate that?
Can we say building administrator? Would that cover, that might mean like assistant principal? I didn't even mean it, like AD.
That may be one way to do it.
I totally am hip to what you're saying though, because a lot of times, like I know in Taconic and Green, I mean, Randy Lowe's office is not in any school, right? I mean, it's a huge area and they're usually not boots on the ground like principals and ADs, assistant principals.
But does everybody agree the goal here is not to necessarily change school administrator as it appears everywhere else in the bill, but to provide more authority for the bill at the building
Yes.
level?
You could just say designee, and that gives the school administrator, latitude to designate someone at each school, or just one, the assistant superintendent, whatever. You would leave it up to the school, to the superintendent or to the headmaster.
So basically, in
Exactly.
line 8, we would just add
A
Or
comma,
designate.
yes, or not even a comma, just or designate. That's my suggestion. If that's what you kind of want to cover.
that's change what people would be in favor of.
Okay.
Okay, we also, the next page, line 8. Providing a student with access to mental health professionals. That was not in the original one. it's seems totally appropriate, yet a little bit kind of out of left field, given that this is very immigration specific. And that it may not even need to be said that a school administrator is going to be looking out for the mental health well-being. And so I'm throwing out to the committee here. I don't have a strong opinion.
Well, I'm wondering if we could rewrite that line to maybe incorporate what Leanne was saying about necessary professionals to help in the healing of trauma associated with something like that.
Might be the guy's chance.
It's a little weird that it says mental health professionals. I don't disagree. It did come, I'm going back, it did come from Joseph's testimony. It's her.
Is that the same language?
Yes, with the clause at the end, and their testimony was, or other supports deemed necessary to directly support the student in school.
All right, so,
I like that better, yeah.
Her full language.
so connecting, so A is connecting the student with the students and the student's family with an immigrant institution. And B, connecting the student and family with necessary.
Providing access to school mental health professionals or other supports deemed necessary to directly support the student in school. It's the language.
That's from the
This is from the BSA, from Chelsea Myers testimony.
That's,
Just take.
That sounds better, yeah.
I would be in favor of just, I guess we do this, right? If a parent is arrested while the student is at school, do we not still take care of that child and make sure that they have access to what they need? It doesn't need to be dictated, specifically, for mental health. Look, SEL, like we're taking care of our students the best way that we can. We have testimony stating they do things above and beyond what's in here. So
Interestingly, the language came at the request of the education community. Who would, I think, would be the first to say, well, we do this anyway, you don't need to state it, but. Yeah, right.
Just one other sort of picky point, the language that Rep. Brady just read, I would maybe suggest eliminating the deemed necessary part, because it seems to set up kind of a weird conflict with providing support to the greatest extent possible. But I think, like the idea is, yeah.
so we'll start the D necessary.
Yeah.
Since we've already got to the greatest extent possible.
I assume this is on your committee webpage, the testimony.
Yes, it is.
Someone can email it to me, that'd be fantastic, just so I have it quickly.
I can do it, yeah.
Thank you so much. You have it handy.
Are there other parts as we scroll through this that anybody else would like to bring up? The rest of it was mainly using the word school administrator.
I will do the background work, but I would, like to check with, just because I think we're running into a licensure term, and so.
Yeah.
School administrator, I just want to
Right.
check that.
Right, and again, the definition would only apply, I'm not saying this, I'm questioning it. The definition would only apply to this part of statute. So that if school administrators use some other statute with a more specific definition of licensure, that shouldn't have an impact here. Okay,
That's right.
right. Other areas, maybe we'll have you then take some of those changes, work on it, and then apparently we could actually have you back later this afternoon.
It's, my calendar is cleared for you all. Most of it.
And, just for the committee's point of view, I'd like to probably move quickly on this just because we are amending it. And therefore, it needs to go back to the second.
Would that require a vote this afternoon?
No, we don't need to vote this afternoon.
We wouldn't need to vote on it at all.
Oh, no, we have to vote down the committee for the whole usual shoot match. Yeah.
Will that be this week, do you think?
Yes. Yeah. We would try for tomorrow. Even. Yeah. All right. I guess you have your marching orders. You'll be back here at what time, Matt? 3:30.
Okay.
Thanks very much.
Yeah, thank you all. See you soon.
And with that, little work by this committee, we have 5 minutes. Is our student already in the waiting room? All right, 5-minute break, 11:30, we'll be